My name is Claire Conroy, and this is my workplace policy analysis. This workplace policy analysis of the Equal Pay Act of 1963 will follow Bardach's eightfold path to problem solving. The purpose of this policy analysis is to look at the Equal Pay Act of 1963 and determine its impact, its efficacy, potential alternatives, and its continued effect on all employees. The Equal Pay Act was an amendment of the Fair Labor Standards Act of 1938. Special attention is given to a bill introduced in recent years by Representative DeLauro, Democrat, Connecticut, called the Paycheck Fairness Act, which could potentially further amend the Fair Labor Standards Act. It is noted that the gender wage gap still very much exists in this country, despite it being illegal to pay a woman a lower wage than a man for doing the same job. Some of the top reasons suggested by researchers for the gender wage gap are: male-dominated industries such as engineering tend to pay higher than female-dominated industries such as education. Far more male employees are in senior positions, and women tend to bear the brunt of childcare, which means that they may have less overall experience in any given industry. It is important to note that the commonly referenced statistic that a woman makes 78 cents for every dollar earned by a man has not changed much in the years it was first cited. Among the requirements of the Equal Pay Act are that men and women in the same workplace be given equal pay for equal work. Job content, not job titles, determines whether jobs are substantially equal. All forms of pay are covered by this law, including salary, overtime pay, bonuses, stock options, profit sharing and bonus plans, life insurance, vacation and holiday pay, cleaning or gasoline allowances, hotel accommodations, reimbursement for travel expenses, and benefits. That quote comes from the Equal Employment Opportunity Commission. The Equal Employment Opportunity Commission, EEOC, states that virtually all employers are covered under the equal pay mandate. Suppose an employee alleges that their employer has discriminated against them based on their sex regarding their pay. In that case, the employer is obligated to defend themselves using one of these four justifications: seniority pay, merit pay, pay determined based on the quantity or quality of the job product, or any other factor besides sex. If the allegations are determined to be accurate, the employee may be entitled to back pay equal to what they should have received, as well as attorney and court fees. The EEOC also states that if one employee's salary is found to be lower than another's based on the first employee's sex, the employer may not lower the second employee's salary to compensate for the difference. There is much more burden of proof on the employer should an employee allege pay discrimination based on sex. The employee does not have to show that the employer intended to discriminate based on sex. A common statistic often heard is that in the United States, women earn 78 cents for every dollar that men do. The more accurate data shows that this is typically only for white women, and the pay gap varies depending on the occupation. Cho and Kramer showed that the higher earning professions such as medical fields and supervisory duties tend to show higher gaps between men's and women's salaries. In viewing the intersectionality of race and gender, there is a stark difference. Bleiweiss notes that the gender wage gap is calculated by finding the ratio of women's and men's median earnings for full-time, year-round workers and then taking the difference. The author does acknowledge that the intersectional realities for LGBTQ+ women, immigrant women, women with disabilities, and more may mean that they earn even less than the data shows. The Equal Pay Act's history began in 1944 at the height of World War II, but the EEOC tells us that it took nearly 20 years before the final bill would be signed into law by President Kennedy in 1963 as an amendment to the Fair Labor Standards Act of 1938. But as World War II continued, women were needed to fill men's roles while men were drafted overseas. More significant numbers of union workers started to press for equal pay. According to the National Park Service, in the year that the Equal Pay Act was signed into law, women made up under half of the civilian workforce, around 37%. but this was up from about 24% in the earlier years of the 1900s. It was, of course, legal to pay a woman less than for the same job as a man. This could be a twofold issue, as the woman did not receive the pay equal to that of a man despite the same effort, but the man might also fear that a cheaper source of labor would replace his work. After the war ended, it was still legal for employers to refuse to hire women, to replace the female employees with men who had returned home, and to lower the pay of the women they continued to employ. In 1961, President Kennedy established the Presidential Commission on the Status of Women at the assistance of Esther Peterson. The latter at the time was head of the Women's Bureau in the Department of Labor. She introduced another draft bill titled the Equal Pay Act on behalf of the administration. Again, the phrase comparable work was proving to be a bone of contention. It was finally amended to equal work, but this did not appease the opposition. As a compromise, the Equal Pay Act was no longer a separate entity. Instead, it became an amendment to the Fair Labor Standards Act of 1938. From the EEOC, we learn that in its declaration of purpose of the Equal Pay Act, Congress declared that gender-based wage discrimination, 1, depresses wages and living standards for employees necessary for their health and efficiency. 2, prevents the maximum utilization of the available labor resources. 3, tends to cause labor disputes, thereby burdening, affecting, and obstructing commerce. 4, burdens commerce and the free flow of goods in commerce. And 5, constitutes an unfair method of competition. The bill also calls for training programs that will teach negotiation skills, promote outreach to women and girls in the workforce, conduct action research on eliminating the gender pay gap and report on the results, research the gender pay gap amongst teenage employees, and work to educate the public on recognizing and advocating against wage discrimination. It is essential that Representative DeLauro's bill includes gathering data and providing education for underserved populations. According to the EEOC, Congress's purpose in passing the Equal Pay Act stated that its goals were to raise wages and living standards, maximally utilize labor resources, minimize labor disputes, increase the free flow of goods in commerce, and mitigate an unfair method of competition. Passing the Paycheck Fairness Act would be an excellent place to start closing the gender wage gap. Because lower income jobs also tend to be filled more by people of color, it would go a long way towards closing the racial wage gap as well. As reported by the Society for Human Resource Management, in January of 2019, Intel, a company that employs over 100,000 people internationally, announced it had reached pay parity for genders globally. The company's gender pay gap was 2.6% globally and just 0.7% in the US, after taking into consideration business factors that account for the differences, such as performance and tenure, far less than the national average. The article also adds that turnover as Intel has decreased since then. It also points out, quite reasonably, that employees tend to look for the jobs that will pay them the most. When the female portion of a workforce is frequently turning over due to low pay, the company will spend more money recruiting and training new employees. Not only that, but, quote, more women in leadership means better decision-making and financial results for the companies, according to a 2017 study by McKinsey & Company. It found that businesses in the top quartile of gender diversity within their executive ranks were 21% more likely to see above-average profitability. Reaching gender parity, it seems, is a win-win situation. According to Little, the U.S. Chamber of Commerce is against this component of the bill. Vice President of Workplace Policy at the U.S. Chamber of Commerce, Mark Friedman, opines that banning this practice has a very negative impact on employers' ability to distinguish between employees. The whole premise of the bill is that the wage gap is driven by discrimination, which we don't think is the case. And if there's a component that is discrimination, it's a very small component. You already have laws on the books saying that discrimination is illegal. Mr. Friedman fails to acknowledge that discrimination prevails and is very much a significant factor, albeit not the only one, in the gender pay gap. It seems he believes, as a white man, that discrimination does not occur if he has not personally experienced it. But prejudice thrives in this country based on many different aspects of one's identity. It is very much prevalent in employer practices. Making something illegal has never precluded it from existence. What the Paycheck Fairness Act advocates for is simple: public transparency of a company's salary practices. It provides education and training for those who need negotiation skills, particularly those who may not understand their rights regarding gender based wage discrimination. Companies would do well, says Maya Raghu, a senior counsel and director of workplace equality at the National Women's Law Center, to set attainable goals in reducing their gender pay gaps. She adds, when standards are more objective and measurable, it can help eliminate bias, unconscious or alert. It is also vital to deliberately diversify interview committees. Diversifying the hiring team helps to reduce unconscious bias when selecting a new employee, as different perspectives are in the mix each time. Why does it matter if women are not paid equal to their male counterparts? Does paying women equally to men hurt a company's bottom line? By law in the United States, a corporation may not lower a male employee's compensation to equal his female counterpart. Instead, it must raise her compensation to be equal to his, according to the EEOC. If a female employee feels that she is not being paid fairly, she has options, one of which is to look for better pay elsewhere. If an organization's leaders are wise, they will work to develop fair, objective standards for how and why employees are compensated. They will use data-based decision-making with a critical eye towards eliminating bias in their hiring and promoting practices. Efforts like this will set up these companies to attract better talent, retain employees longer, and overall stand out amongst others in their industry. Diversity, equity, and inclusion must be core values for every organization. Those against reforming our policies to address pay disparity would do well to look at the bigger picture. All humans have unconscious bias. We must seek to actively work against gender discrimination by acknowledging that it exists and that its effects are real and harmful. Both employers and employees need to train themselves to specifically recognize what gender bias looks like and sounds like in the workplace. As they do, their actions will have a ripple effect on other areas of their lives. Understanding how gender bias happens is the first of many necessary steps towards true equity. Along the way, we must use regulations such as the Paycheck Fairness Act to protect those who work for corporations that do not care to address or are not aware of their bias. We can avoid people requiring public assistance if they are paid fairly. We can incorporate more productivity and talent into the workplace that we would have otherwise missed out on. Only by thoroughly examining our bias and seeking to make data-based decisions rather than those based on gut feelings or prejudiced choices can we hope to close the gender pay gap.